Notice must go to, under the New York law, affected employees, their union representatives, if there is one, and certain government officials. I said under New York law a second ago, I mean, this is generally the requirement under the federal statute as well. The government officials that have to receive notice are a little bit different under the two statutes, although there's some overlap. But the only real nuance here is the federal statute didn't require separate notices to individual employees. If there was a union representative, you could just provide it to the union representative in lieu of directly communicating with the employees, but the state law specifies that the employer must notify both the union and each of the affected employees. Important under both laws, affected employees, again, does include part-time employees expected to suffer employment losses. So if you remember back, I made a big point to note the part-time employees, which actually can include some full-time employees who haven't worked there very long, but nonetheless from that, the part-time employees don't count in determining whether you have to give notice, but if you do have enough non-part-time employees to have to give notice, then you also have to give notice to the part-time employees who would also suffer employment losses as a result of the mass layoff or plant closing. Notices to government officials, for example, will include lists and identification of who the affected employees are, but otherwise they largely contain the same type of information as what goes to the individual employees.